Welcome to June's Planning Lunches at Noon. Next steps after plan approval. I am Brendan McDowell, a principal planner in the Office of Planning and Development at the New Hampshire Department of Business and Economic Affairs. This webinar, as a reminder, is eligible for AICP Certification Maintenance CM credit. So any certified planners who complete this course may claim CM credits in accordance with APA/AICP guidelines. All right, so we've got a good webinar for you. We've got Cynthia Dea Boisvert, president of Arago Land Consultants, Kelley Monahan, Registrar of Deeds, Grafton County, and Shane Conlin, the City of Somersworth Code and Zoning Enforcement Officer. We're excited to have them. Just really quick before I pass things along to Cynthia, here's a reminder of how to use Microsoft Teams webinar controls. Please put your questions in the chat. We will do our best to answer them towards the end of the webinar. I'll be collecting any questions you have on a separate document, and I'll be facilitating a Q&A at the end. Which we should have time for. Today we've got an hour and a half long webinar, so a little longer than our usual hour. So hopefully we'll have some time to dig into some questions at the end. And with that out of the way, I'm going to turn things over to our first speaker, Cynthia. So if you want to take it away.
Hi, Cynthia Dea Boisvert, licensed land surveyor. I practice out of Amherst, New Hampshire. There's my information. It is ARAGO. So I included a lot of RSAs relating to surveying. There are many different types of surveys. There's septic surveys, there's forestry, they can do some type of surveys. Engineers can do a survey for their perhaps design work, but only land surveyors can prepare a plan and do boundary determination. So that's a very clear thing that I just wanted to make straight with you. I'm not going to go through all of the RSAs. If you click on the links, I did underline some items for you, but the most important thing is for plans to be recorded at the Registry of Deeds. There's a plat law that guides all of us. Anything to be recorded has to have a specific area, a boundary defined by meets and bounds, and that's bearings and distances, and then the appropriate certification with our seal, the town's approval blocks, and our original signatures, and the town's and the dates we signed them have to be in black ink. That is a key thing of the plat law. Kelley will probably go into more. There's been a lot about e-recording, yet I'm not going to get into Kelley's things, but I've really tried to work with them. But it's very important that the plan that we sign and stamp is the plan that gets recorded. That it's somebody else doesn't have it or try to edit it or anything. The other thing regarding the plat law is you can have no shading over text. There's a minimum text size. It's 1/8 of an inch. We always, in the old days for drafting, we referred to it as L80. And that's so that because all the plans now are scanned and then they're reduced, and you've got to be able to read those plans. Some people print them out on 8.5 by 11. Most of the plans that we submit are going to be 22 by 34 inches. So the plat law is very specific of certain sheet sizes, but so a plan has to be able to be read, and therefore another important thing is no lines through any text on the plan. So for a boundary plan, if it was a strict boundary plan, there's not going to be a lot of extra information on there. But when you get into site plans or other plans that towns might require as part of their approval process, there is a lot of data on those plans that the isn't that can really bog down the specific things of the area, size of the lot, and the meets and bounds of the parcel. I always refer to, for a site plan and the plans that the towns are really involved in, I always would like to have the a land plan. So there'll be one plan that is strictly, let's say, the original boundary of the parcel. If it's a subdivision, then there could be several pages where then we're going to see all those new lots. So, but those are the land plans. On those, you could have, the towns could require, perhaps the flagged wetlands, setbacks, things like that, but we don't like, those aren't the important things for a recorded plan. The important things is the actual legal lot, meets and bounds, and area. So that's the plat law, and it's actually, I do suggest you go look at it, but it is really very simple, and therefore being very simple, it's kind of surprising how many people have a tough time with that. The next thing is the state has, for all professionals, has things regarding professional licensure and certification, and a land surveyor is the specialist in measuring land and determining property boundaries and subdividing land. We have very good parcels that might have great meets and bounds, and then we have parcels we have to determine the boundaries because the descriptions are so old, and it said it was bounded on the north by Cynthia, on the east by Mary, on the south by Bob, and on the west by Fred. We have to determine where are those boundaries. So there's just so much that a surveyor has to look into, and we are the ones who can determine it. For myself, I do a lot of deed research to determine that boundary. And I do use tax maps and GIS for that base plan where I'm going to do all my research. But by no means would I ever use the town tax maps or GIS for boundary determination. And I think that's a very, very important thing, because you might get a lot of people that come in and say, well, I got this off of the town GIS. It's just, GIS is just a great big picture for us all to use. And let's see. All right. We did that one. So it's also, I skipped one, sorry. There's a provision that if anyone offers land surveying, it's a Class B misdemeanor. But if anybody actually practices land surveying, it's a Class A misdemeanor. We as surveyors have a tough time policing our profession, but we really do try to stay on top of other professionals. Oops.
Oh, I just.
That's okay. I got it back. We try to really contact other, if a professional has, made that they're advertising that they offer surveying. I belong to New Hampshire Land Surveyors Association, and we really try to contact them and say, you really cannot advertise that you offer surveying, because it's like a septic designer. They can survey the parcel that they're going to do, but they can't really show property lines or label them as such. They do have to make sure they're on the correct lot, but they don't have that authorization with their license to really say this is your lot and that's where we're going. And again, as I said at the outset, there are different types of surveyors that engineers, the government, and foresters can do, but they cannot do boundary, right-of-way, or easements. that's as strictly can only be done by a land surveyor. So think of it in your, let's say in site plans, and there's a lot of, you're doing a site plan, and then there's going to be easements created for sewer or water or anything like that. They will be shown on that, but then it has to have a surveyor involved to figure out where legally are those easements, and then we create the bearings of them, the limits of them. And I'm a big fan of, if you have a plan and you've got a drain and there's a drain line, that the easement should only be, let's say maybe 20 feet wide total, 10 feet on either side of the drain line. I hate to encumber lots with too many easements. I think that the builder, the town for a drain easement they want to be able to fix those pipes and get to them, but they don't need to have rights all over those parcels. So the towns, you really need to be careful how you do your easements, because for most people, their home lots, their new houses, these subdivisions, or even a site plan, they do want to have that control over their parcels. So that's my opinion. And professional engineers, rarely now do professional engineers do their own surveys. We work very close with civil engineers, and in the same way, I could grade a site so that it drains correctly, but they really are very specific about the grades, how much on the slopes, especially New Hampshire, how much rain is coming in, where's it going. So I let them do their job, and they're very good about working with surveyors, and let the surveyors create those boundaries and the limits of where they should be designing. With regards to that, there could be, if there's an existing boundary of a piece of property and an engineer uses that record plan and perhaps hires somebody to do the topo so they can design it, on that final plan, they cannot show the meets and bounds of the boundary unless they are extremely specific, saying, giving credit to the original surveyor, and that original surveyor should have been notified that his boundary was being used for that site plan. And that would be, let's say with regards to towns, that should be part of the notification, a butter notification. We do get notified a lot when someone else uses one of our boundaries, but that's something to think about, because the engineers can't own that pre-existing boundary. It's only that original surveyor. So for towns, the planning board order of conditions, there's a lot of order of conditions, and rarely do towns put any order of conditions that affect a boundary. But creating an easement, that would be, and that should be on that land plan. But a site plan should not be recorded, and the reason for that is when a site plan goes through your town's planning board process, that is all proposed items, and we have no control over when it will be built, how it would be built, and that. And so if you want to have a plan recorded, you really should only be recording the land portion of it, not a proposed building or anything. And that's a grading, a sewer. And those plans, when you receive them in your towns, so the engineer should be signing and stamping the the design plans, all of that. An architect will design if you require, building plans. There was one town that they used to require that the surveyor, they had a certification that it had to be that the surveyor had to do it. Shocking. I refused to sign those plans. I said, no, I'll sign the land plan, but I can put that certification on the land plan, but you have to have an engineer do it, because I would not certify to somebody else's work, nor do I expect them to certify to anything that I had done. So there's that. Oh, and I guess that was the end of my thing. I also want to say, we do have the New Hampshire Land Surveyors Association in New Hampshire, which in every single town, there's so many great surveyors that belong to our association. So if you need to contact our association or any one of us with a question regarding what's going on with this, you might want a non-biased opinion of someone who's not presenting before you, please feel free to reach out to our association or myself. So thank you. I'm done. Kelley, you may take control.
Okay, thank you. Thank you, Cynthia. Can everyone hear me?
I can.
Okay. Good afternoon, everyone. I'm Kelley Monahan. I'm in Grafton County. First off, you go with Register of Deeds. We like our Constitution, that's register on the ballot, and stick with Register of Deeds for identification. I first ran in 2010. I moved to Orford, New Hampshire in 1998 to my forever book farm with my 3 babies. And what an interesting experience I've had in the no zone fabulous town of Orford that led me here in wanting to help people understand. I love the whole planning process. I truly enjoy my position here, and of my age, I'm 65. I consider myself, I'm the oldest of 5. I've raised 3 sons. I'm now a grandmother. I consider myself a communicator who mothers gently but firmly. No one likes hearing no at that counter. We try to deliver it with proper understanding and explanation, but we are the gatekeepers of the official public record, which is, in my opinion, let me see, is the cornerstone of our economy. We all share the same goal, as you can see, and that is the lawful recording to the official public record of all documents that conform to the standards and are accompanied by the correct taxation and fee payment. That's a whole another issue, very visible on all of our websites and in New Hampshire law. This information is easily referenced on our websites at nhdeeds.com. So a great deal of effort went into developing plat law for good reason. Before that, let me specifically talk about Grafton and Coas a little bit. We are so land rich. Grafton, as is often said here politically now, we're the size of Rhode Island plus 500 square miles. Coas is even bigger. How we are different from some of the other counties is we have land that has been in the same families and hands for generations. As we developed, as we saw in COVID, many of our sister states and friends to the west and south are looking to move here. It's a glorious place to live, as we all know. But as land starts to feel the pressure in Grafton County and Coas to come out of current use and to transfer hands from this generational ownership, we're going to go back to really old documents that predated plat law. I'm going to riff a little bit here on and do some patting on my back of me waiting for ARPA money, American Rescue Plan Act, to use. I used about $1.5 million. There was some serious arm twisting and lobbying and salesmanship that went on my half, but we had so many plans that predated plat law that were stored in scrapbook format, mixed media, blueprint, tissue, paper, all folded, taped, all compressed into scrapbook. They did the best they could in the 40s and 50s, the best we could. These books, there were hundreds of them. Of course, they were scanned, I believe, in the 80s into the record. The scans were iffy. Our eyes are not great. We're on computers so much now. So it's really important, that crisp image on the internet that's saving everyone time and money from traveling to far off North Haverhill and Lancaster up in Coas. So I used ARPA money to take apart those old books, have them restored, encased in Mylar, redigitized, and back up on the internet. So that was, in my opinion, a fabulous use of ARPA. I'm hoping for some national recognition with NACO for that project because it was really significant here in Grafton, and it was so rewarding to be part of that. So a great deal of time and effort went into plat law for that reason. Some of these older surveys are absolute works of art. I'm just in love with them. but I'm a geek for all of this. So let's talk about the roadblocks. I insist on mutual respect at the counter. I don't like any staff in New Hampshire getting beat up or bullied, and I expect the same from the staff to the person recording. Everyone's learning at different paces. So many of our small municipalities, it's all citizens, and so many of our smaller municipalities can't afford a planning consultant. So they're doing the best they can, but proper guidance and educational opportunities like this that I preach until I cannot speak anymore are a fabulous benefit to help everyone achieve the same goal. So issues, a hybrid plan. I was starting to be sued by 2 lawyers last year, 2 attorneys in Grafton County, because they took an already recorded plan, cut and pasted a section of it, wanted to record it as an exhibit for an easement. And I pushed back, and I made both of them understand. They're both going to sue me. And I made both of them understand. You are trying to bypass plat law and the surveyors. We are a land state. When I first ran for office, GIS was being pushed really hard. I won't talk about the players. That's still a sore subject. But I said GIS is a hobby. It is not the legal description. Legal description is a very important term. The verbiage in that deed is the legal description. So a lot of times, and I don't go to national conferences anymore because everything's available online, but to national conferences that I did go to the birch tree, to the stone wall, to the apple tree. It's real. It's in the documents of these old documents. So hybrid plans, pulling pieces and then trying to bypass the system. We're going to reject that across, and calling it an exhibit. We're going to reject that across the board. Go back to start. Chain of custody, big issue for me. Unsigned plats. Best practice. Once the plan has gone through everyone's work and presentation and approval and all the gyrations, signed by the planning board, that's a hot document. Best practices should be in the hand of the chairman of the planning board, a trusted member, or the surveyor. Giving it back to the property owner, or it happened to me last winter, a real estate agent who really needed the deal to close, he got scolded, is dangerous. Someone could alter something. I think back in the day, a few registries were sued over somebody potentially. I went to court over a potential. He was questioning the line. He said someone came in and changed it with a pen. I went to court. I looked at the judge and I said, Your Honor, this blueprint is in blue. This little line, they'd have to imitate the exact same pen under the watchful eye of the register at the time, Bunny Woods, our longest serving register, who patrolled the floor. The internet has dropped off our populations who come to research here, which is good and bad. I love that room being filled with the networkers and the communication and the synergy and cooperation. It's sad, but we're all trying to save money and time. So chain of custody is a big thing for me, and altering, people, unfortunately, our society, we got people who aren't necessarily playing with the best intentions. So that's a big issue for me. I wish every planning board would understand that chain of custody thing. Double-sided documents. This is easing back. These present a problem, as now, because of computerization, the recording process begins with us eyeing the document, making sure the payments are number one, that the document's in our county. That happens. People come to our county and they need to record in Carroll or something. So we eye everything, but it goes in the scanner first to come up on the screen, and then all the checklists start. So it's very complex now. It's just not bringing in a paper and us stamping it and hooking it back in the file. So DES
Kelley,
was,
I'm sorry. It's Alvina. You're not advancing the slides, so people are not.
yeah,
we're
I'm still
on the
talking
chain of
double.
custody.
Oh, I advanced mine to double-sided documents.
Oh, I'm still on 17.
Okay, mine's on 18. I just moved it to LCHIP.
Okay, that's double. I have double-sided documents.
Okay, so for some reason mine's one ahead.
LCHIP now.
So,
Yep.
okay, good. Okay. No, mine just skipped ahead. So I'm going to be, I guess, one behind. So I'm going to stay with LCHIP. Is it on LCHIP? Okay, let me just quickly talk about LCHIP. Just had it. Won't want to name the town because I live there, but new planning board chair didn't know what L-chip was. I gently spoke to him. And it held up the recording for a week and a half to get a $25 check up here. Checklists of new planning boards. And also the planning consultants. We have a planning consultant that we pay. And this got missed. So the applicant actually was bugging me. Why is it on record? So just look at the specs before you show up at the counter. You know, it's a long drive. No one likes wasting time. Checklist is a great tool. I did it for 9 years ago, and I guess it went along the wayside. Excess information requested by the town or applied by a surveyor engineer. Excessive topo. That's sort of, we're not seeing that issue as much, but one register had to tell an engineer that he said, "You're destroying my creativity," because it was in 7 or colors or something. And she said, "Take an art course. This isn't about creativity. It's about clearly reading what you're recording." So excessive topo, which confuses the plan. I know the town's requesting a lot of different stuff. Separate sheet for the towns. The documents that they, I just scolded one. Brenda, my deputy, who's been here 34 years, a genius. Reduce documents, associated documents, and put them on the plan. That's just trying to save a few bucks. Reducing a document in size and pasting it on the plan, I'm going to reject that. I'll speak to the other registers at our next meeting about that. Stop cutting corners. It's not for the purpose here. The purpose is just to read all of this stuff in 60 years. Can you imagine how small the font is when you shrink down a document that's been shrunk and put in a corner of a plan? You can't read it. It's legibility. It's legibility in all media. Okay, I'm going to go to solution. Oh, there we go. Silly me. So we'll reject that. Separate sheet. Please, separate sheet for the town-specific requirements. We're going to have a lot of oddball stuff coming up, especially in the rural towns. And a lot of waivers are going to be requested. So a separate sheet for the town-specific stuff. Now that towns have ability to scan and put it in their own files, there's no excuse to be jamming stuff on a plan that's here just for taxation and ownership purposes. Responsibility of the register. We represent a major cornerstone of the economy. It's a silent engine that a lot of people don't even understand. The official public record consists of many moving invisible parts. You want a credit card. Sometimes people are even going to, credit card companies are going to even look at what you own in property. Of course, refinancing. They're going to look at everything. So we're critical for people's financial stability. It's America. We love our land. We love to own our land. It's a very important piece that people overlook, especially during election cycles. Our primary objective is that the recording is clarity. To be able to read and analyze into perpetuity should be everyone's goal. Take an art course if you need to be creative. Summary, share the knowledge. It's so easy to just, bring it on a new surveyor as an apprentice. Hey, this, that, and the other. Visit your register. Get to know your register. But share the knowledge with each other, with your towns, especially our municipalities. I constantly tribute the planning board members and their service to their communities. Thank you. I'll answer questions in the end. And now I'm going to turn it over to Shane, correct? Take control, Shane. Thank you, everyone.
Can everybody hear me okay?
Yep, there you are.
All right, perfect. Thank you, Brendan. Good afternoon, everybody. My name is Shane, here with the City of Somersworth. I am the Code Compliance Officer. I work primarily in the Code Office, but I do have an overlap with our small planning office with respect to site plans, planning board approvals, and the like. First off, I'd just like to say thanks to Kelley. She mentioned the importance of just follow through on the rules. Details count in this type of work, and it has a big impact from the start to finish of these projects that sometimes get folded over into different ownerships and different projects. So I just want to say thanks for that. So for my position, I typically deal with the fallout from a planning board approval. So after the project has gone through the public hearing phase, typically there'll be conditional approvals put out by the planning board. The state has a good reference material. I'd encourage everybody to at least have a copy of that if they're involved with planning, to review the manual or take the exam that the state offers. It's a good resource. But essentially, after the planning board process, they'll have conditional approvals. You know, the planning board's decision to approve an application with conditions are really going to be necessary for a variety of reasons, right? So every project's different. Could be a new service station, could be a residential neighborhood. They're all going to have different conditions based upon you know, surrounding site conditions and on-site conditions. It might vary from, you know, minor revisions that were during the planning board process, permits, you know, waterfront development that requires maybe DES, EPA, Army Corps, even Coast Guard approval for coastal waterways, or anybody along a highway that might, you know, need DOT approval. Those are all conditional approvals that we'll address here a little further down the line after a planning board approval. You know, again, going down the list here, improvements to roads, sewers, utilities, and the board may also want to require conditions to address abutter concerns, you know, discussed at the public hearing. That could vary from landscape, buffering, lighting, photometric requirements, signage, traffic measures, anything that might, you know, impact the surrounding community with a variety of nuisances. Next slide. So if you go by the planning handbook, you know, there's two general approval categories. There's conditions precedent and conditions subsequent. Conditions precedent are conditions that must be fulfilled before the planning board gives a final approval and the chair of the planning board signs off on the plans. Some of those might include what we just talked about, other state permits or federal approval, bonds for construction, stormwater management plans and agreements, and recording with the registry of deeds, maybe some other necessary plan revisions that the planning board required. Conditions subsequent are other conditions that will appear on the final plan and deal with restrictions on the property and safeguards during, after, you know, construction phases. Some of those might include preservation of on-site landscaping, maybe trees over a certain size, stone walls, erosion controls, lighting requirements, traffic requirements or controls of traffic requirements, hours of operation. The limit's endless on, you know, depending on what type of site it is. Here's just a little snapshot of a couple of conditions precedent in one of our notices of decision from a planning board approval. Just saying that plans shall bear the stamp of an engineer, licensed land surveyor, and landscape architect. The size and dimensions of the plans is interesting that we have 24 by 36, but I believe Cynthia mentioned a different size. So I'd like to hear from her at the end about, you know, recording of plans and the proper size. But, you know, these are types of conditions that we'll have before the chair of the board will sign off on the plans. Just some subsequent conditions, you know, this is for a sixplex residential property, new addresses through the E911 committee, performance surety for the, you know, the project, water and sewer connection permits. These are all things we'll verify before folks will start digging in the ground. And one thing I'd like to point out is that, you know, not every city is going to be the same with this, right? So backing up a little bit, we have the two different types of conditions. It's not always going to look like that. And I noticed a decision from a planning board approval here in the city of Somersworth. We actually have 5 different approval categories. So we have number 1, plan revisions, 2, conditions that must be met before final approval by the chairman, conditions that must be completed before site work, conditions during and after construction, and as-built plans. So it's not going to be separated necessarily into 2 different categories. We have 5 here in the city of Somersworth, but they all fall under the conditions precedent and conditions subsequent. Now, I would like to point out that the conditions precedent have a 120-day time period here in the city of Somersworth. So if you've got survey plans, recordings that need to happen, you've got 120 days to get that stuff completed after your site plan approval. Here in the city of Somersworth, if you don't meet that 120-day period, you do have to go back before the planning board to get an extension. Some cities, like the city of Dover, allows staff to provide those extensions. So it varies from city to city what's allowed. This is not something that I typically deal with on a day-to-day. It's more of our planning staff, but I just want to cover it. Posting a bond or other surety. At the end of the day, the municipality wants to make sure that whatever project is being carried through during the site plan and construction phase is going to get carried out as indicated. So as part of that, the city, here in our case, city of Somersworth, requires that a bond or other surety is placed, depending on the project. It's a different amount, just to make sure that the project is completed as signed by the board. And it can include different sureties for landscaping, building, utilities. I will note that posting a bond or surety is not required for folks that are doing a subdivision with respect to roads and utilities. That's a RSA change from 2023. And enforcement. This is a tricky thing. It's something I deal with here in the city of Somersworth. It's kind of the one of the main categories of my job. Non-compliance issues will happen at some point. Not with every case, but it's pretty common. And there's several options for enforcement. I don't know how many planning board members there are on this call today, but I would say that details are very important with respect to site plans, and thinking of them from a code compliance perspective is important. How enforceable they are and how realistic they are to be enforced is something to take into consideration. But I'd always say before any enforcement procedures take place, it's always important to seek legal advice, because there are a large variety of measures to go with, enforcement measures against a project or a site plan, or a tenant with a site plan on a specific piece of property. I always try to seek voluntary compliance. I always say nobody really wins when they go to court. It's an expense on just not only time, but a monetary value to both sides. I always try to reach out to folks and, work out what can be worked out within the parameters of the site plan. More often than not, folks are willing to comply with the site plan because ultimately that's what was approved. But there are conditions and situations where that just doesn't work out. And in those conditions or situations, there's RSA 676-17, A and B, or RSA 3139, that's regarding ordinances, that, give the city or municipality or town some teeth to enforce the site plan. Now, there's also the option the site plan could be revoked by the planning board. They could have a compliance hearing. We've had a couple of cases in my time here at the city of Somersworth where, we've gone to the property owner that has the site plan. We've gone over the non-compliance issues. We've pointed out maybe a subsequent condition that they're not following. And for whatever reason, they just refuse to follow that condition. We'll bring them to the planning board, and they'll have a hearing to discuss, the merits. They'll have the neighbors come out and go through that process. And hopefully through that process of, bringing forth it to the planning board, brings closure to the case, but not necessarily all the time. So that's when we unfortunately have to start a case, Dover District Court or Stratford County Superior Court to bring resolution to the site plan issues. And I think from there, we'll just take some questions.
All right, excellent. Thank you so much to our speakers, Shane, Cynthia, and Kelley. We really appreciate having you. We do have a couple questions. I thought maybe we could start. There was sort of a crossover question with between Cynthia and Shane. I can back up to that slide. I believe it's this one regarding the size of plans. Cynthia, do you want to speak on that?
Yes, the plat law requires plans to be, when they're recorded, to be 22 by 34, 17 by 22, 11 by 17. So that's where the land plan would be, it's a smaller plan. So if you have a subdivision set, those land plans need to be, the largest is 22 by 34. I know most engineers, right-of-way plans, sewer design, engineers normally use 24 by 36, as do architects. But to be recorded, it has to be a 22 by 34 inch sheet, and it cannot be reduced from the larger size down to that size and then recorded. That plan has to be to a scale, as well as having a bar scale, so that anybody who gets a copy of it, even if it's a reduced size, can figure out what the plan is. I think for site plans, if towns require a 24 by 36 inch, that's fine, but the towns also have to realize that anything that's going to be recorded is the 22 by 34.
All right, excellent. So I was thinking I could start at the top, and so keeping it on you, Cynthia. We've got one question from your section, and I'll keep track of the chat in case anybody puts any other questions in there for you. And for the folks who are here, if you want to. In the chat, if you had a specific question for a specific speaker, if you wanted to call them out by name, just for everybody here. All right, so Cynthia, here's your question. So when looking at maps, tax maps and such, what is the best practice to determine boundary lines? For example, someone comes in with a discrepancy or a boundary line complaint. Do they need to get it surveyed before asking the board to make a determination?
Yes, they do need to get it surveyed, because surveyors, so when we survey a land per parcels, per our requirements for licensure, and I always tell people, we survey the land, we don't survey for a client. So my responsibility is to all abutters as well. So if there's a discrepancy, then you do have to get the land surveyed. So that I don't think a town should want to accept anything if someone comes in and says there's a dispute. Even on zoning items, if a neighbor stands up and says, I disagree with this, I don't think that's where they want to put a shed in the setback line, and maybe that's where a fence is. That fence may not be the property line. Therefore, the zoning board should say, you two need to figure this out and probably get your land surveyed. It is an expense, but the town doesn't want to own anything like that. So I don't know if that answered that question, but if anybody talks about a dispute, get a survey. The other thing is, I guess with regards to this is, when we do our research, we're going by the legal descriptions. Kelley mentioned that. We're following that legal description. What is the land? We're not, we take into account ownership, but we don't, a lawyer is in charge of ownership. The title, that's different than the surveyor who's, I might be surveying your property and I'm going to show your name and everything and the deeds and everything. But my final plan isn't certifying to anybody's ownership. It's certifying to the boundary of that parcel.
All right, excellent. Kelley, did you have anything to add to that? I saw you.
I could add to that with just experiences that we're seeing. You know, COVID brought a lot of people to the hills. Sadly, we're seeing a lot of disputes, especially in our small rural towns and class 6 roads. People are moving pins. People are bullying each other. I'm being ridiculous with be a neighbor, be a good new neighbor, be a good old neighbor. I say the Latin term caveat emptor at least once a week. Buyer beware, know what you're doing. If I could accomplish anything, it would be talking to the real estate community, the real estate salespeople, and say, be fair. Tell people that they should check out what they can do before they sign on the dotted line. Because it's causing conflict. People assume that they can do things without knowing the rules.
I would also echo what Kelley said. We have a lot of investors that buy property sight unseen. And I've run into a bunch of times where people buy a property and they're completely unaware of what they own. They've never set foot on a property. They just bought it, and their real estate agent took a look and maybe told them that they can do X, Y, Z.
Yep.
And that happens quite often.
It's creating hostilities. I've talked to 2 police chiefs this winter over disputes way far down rural roads that were heating up. You know, while people are coming in, they'd have no idea. They're dumping gravel. I own this road. No, you own this road. No, oh my goodness. We're going to be in court for 10 years in our rural counties with this stuff. And it's bullying. And it's assuming without following through and reading your documents and knowing what you're talking about.
I think up in Kelley's neighborhood, but an interesting thing for surveyors is we do have a lot of parcels in New Hampshire that are bounded by stone walls. We as surveyors, when we locate those stone walls, we had better locate where there's any break in that stone wall, because that break is indicative of another parcel might have rights to cross through there, either through the cows or whatever was going on. If we see a woods road, we better locate it, because it can indicate other people's rights. So yeah, you can't assume.
And if I may add to that, a right of way for logging does not. I mean, all kinds of understanding from other states that are not applicable here.
Kelley,
Yeah.
we lost you for a second. If you could just repeat.
I said people are of course immigrating from other states where. So oh, I just lost my train. So checking what you're allowed to do before you assume what you can do. Even getting utility in, assuming that a right of way for logging is not automatically a driveway. So I see at the state level what the legislature did on class 6 roads and the waiver on okay, you can have insurance. This is going to be a big issue for Coas and Grafton with people way back in the woods. Logging issue was a right of way to log is not necessarily a driveway, and people are assuming that.
Yeah. And another thing with regards to logging is I surveyed a big parcel up in Ossipee, and the loggers will blaze trees where they think the property line is, and it was a whole bunch of surveyors were out there. We were going to put a proposal in for this survey, and every single one of us said, this isn't the property line. So a blaze is where you cut on both sides of a tree, and those blazers by loggers are indicative of them. Don't clear any trees over here. But because of the way this was, it kind of made a big bow, that they probably did clear some trees on somebody else's property. So and again, that's forestry. They can survey for the purposes of what they're doing, but it is not indicative of any right-of-way boundary line or anything like that. So, and another thing I think for towns you need to realize, we had another wetland scientist, and especially handheld GPS is the bane of my existence. A wetland scientist located the wet flags, and then we had done test pits so we could find out could the septic loading and everything. And where that handheld wetland scientist located her wet flags compared to where our surveyors then located and compared them on the ground was up to 60 feet off. So for that case, we had our plan, and then we took her location, because there were so many wet flags out there, that we had a separate plan, and she signed and stamped that. But I guess I wouldn't put her flags on my boundary or anything, because I couldn't certify that it was the same. And it did really, it's different purposes. Wet flags can be close up to 5 feet, where if a surveyor locates a wet flag, that's right where it is. It's like, to the nearest hundredth. So there's different types of location in the field. So if you get that kind of case in you have a separate wetland flag, just take that into consideration, that those wet flags were probably located by that professional, and that's okay. But the surveyor doesn't have to certify to it.
All right. Yeah, that's all really, really good insight. So we've got somewhat related. I'm jumping around a little bit. Somebody asked, have any municipalities switched to electronic records for final plans? Any best practices to keep in mind? This is for the group at large, I think.
If I may, towns can do whatever they want. We have a system called Monarch. We used to, by law, we transfer all ownership deeds, documents back to the town once a month. Now with this Monarch program, it's streamed that the towns can get at any time and see the transfer in real time, which is great. It helps the town understand what's going on with transfer and taxation and who's doing what where. Lost my train of thought on that. Don't know where I was going.
That's all right. Anybody else?
For the city of Somersworth, we require physical plans, but if people want to send them digitally,
Okay.
it's just an add-on basically at that point.
So now, as the towns get more sophisticated, we were lacking internet in many towns when I first became registered. So as the internet's progressing and everything, the towns, once that plans come back to the town and they can file, do whatever they want electronically. I spoke to Cynthia at our great Association of Counties conference last November in at Mount Washington. We brought in Bud Fitch of the AG's office to understand e-recording and why that's a roadblock for plans. The systems aren't ready to handle it. We don't have any mechanism for associated payment. We're not going to record a plan without payment. It's taxpayer dollars. So unless every surveyor wants to contract with the middleman, which is the e-recording company, I've limited our cooperation with only the top 3, which is another expense and another process. That's the only way at this present moment we're going to even talk about electronically recording any plans. If we approach this in a few years, we should do it mutually with the Surveyors Association and get together and hash this out and then approach it. What's happening with PDF is they're breaking PDF into PDF engineering, PDF-A for architecture. So PDF is evolving. The e-recording companies are evolving. Actually, our software vendor is setting their toes into the water to become the middleman themselves. So it all stays in the same chain of ownership. It's going to be very interesting to watch this happen. And we may even get a little piece of that action, which would be interesting to offset for the taxes. We, as registers of deeds, we have very different income levels based on volume. And that's our operating costs without affecting the taxpayer. So it's all very complex, the e-recording piece of it.
All right. Do you have more to add?
No, I'm all set.
Nope. Okay. All right. All right. Let's see. Let's look at some of these other questions. So this is another one I think for the group at large. So what happens? So we were kind of touching on this a little bit a few minutes ago, but what happens if there is a discrepancy between the deed measurement and the actual distance between bonds? This is especially vital as it regards road frontage.
So it happens all the time. I'm working on one right now. It's like, so what the surveyor locates in the field, that is the distance. Let's say for frontage, if your deed said you have 500 feet of frontage, and then I go out and locate in between the two, let's say 2 stone walls, and there could be curves in there, and then curves make a difference, but if the frontage is going along those curves, it's not going in a straight line, you might not have that full frontage. By the same token, you could have a heck of a lot more frontage. So, but what the surveyor, when they locate it, that is the frontage. Somebody else had asked a question about, let me see where it is. It's on the same, on the same idea. We'll get to that question again, but I would, the final survey, they had asked if you could survey just a portion of a lot. I highly recommend against that, and the reason being is that towns used to allow that, and let's say, and I have a piece right now in my hometown that they broke off a lot of pieces from this farm, and now in that zone it requires 200 feet of frontage, and she now has remaining 367 feet of frontage. She's got 5 acres. It's 2-acre zoning. She needs to get a variance for frontage and width. And it's been a big fight. And you look back and it was, she inherited the land from her parents. Why was it left that way? Well, my guess is nobody had looked at that total frontage for her. It should have been thought about. So you could do a really tight survey of just that portion of it, but my recommendation is that then that surveyor go and they could do a not an urban, you could do it's not compass and tape anymore, but we do that a lot on large parcels. We run around it, and it might not be as accurate, but it is giving that owner, this is how much other land is remaining here, so that they may want to adjust things. And I don't think most towns allow a subdivision or a survey in New Hampshire without surveying the whole parcel.
And if I may on that, we experienced that quite a bit in Norfolk because it'll ultimately come down to your road agent if it's safe in that bend in the road to put a driveway for visual sight, if it's safe. Sometimes it'll come down to the road agent to make the determination, which I find very interesting. When my deed said I had 10 acres, it took me 7 years to get a surveyor out, and I had 8.42. So, we just followed the paper trail, do your work, figure it out, because they did the best they could. I have a really cool property. The frontage is the last remaining miles of the trail that the Abenaki had that connected the Atlantic to the Pacific, to the Connecticut River in Orford. I love my stretch. And I was a sheet meadow. I have stone walls on all 4 sides. We've got really interesting land in the state of New Hampshire, but it was as accurate as they could be in the day.
Right.
Very cool. All right. Let's. I've got a couple questions for Shane here, so we can kind of go. And I think I still got one more question for Cynthia and Kelley as well on deck. But yeah, I've got a few for Shane. So, um, is it necessary or good practice to record a notice of action in conjunction with the filing of the final plans?
That's not a practice we do. I mean, Kelley, do you see that at the registry?
I'm going to be honest. Brenda is the gatekeeper. Early on, people were squidgy about me running for office and I found out why. Because they had tax liens. So I make a practice not to look at every document that comes in here for that reason. Because number one, our database in Grafton is 6 million digitized images. I have a developer hounding me right now. Help me out. I can't find. I'm like, that is not my role. That is the role of your attorney.
Yeah, I think we just require, deeds, easements, those types of things to be recorded with the registry of deeds.
Yeah. Sometimes, things that help explain things are good, but I'll have to check with Miss Brenda on the she's a goddess. She's on her cemetery commission. She's the chair of their planning board in their little town. Supervising the checklist. She's a goddess. She knows everything.
I know Massachusetts has a lot of notice of intent. Let's say for certain types of development, maybe you're going into the buffer, and then you have to once it gets built, they need to have a wetland scientist go back and say yes, everything was built, and then that can be negated. And just for the residents in all your towns, that's very difficult, because if there was a notice of intent on a parcel, which might be that same notice of action, if it wasn't released, what is the burden on that? How could that be sold? I think you have to. That's more of a legal thing. We don't have a lawyer on the panel, but those are funny things to think about. That it could be tough on the title.
And that's who's running the world is title and insurance. They're the ones. No, we're not going to insure it. We're not going to insure you.
Right.
Brendan, for the next question from Jerry Bernstein, I did do a quick read through the Francistown site plan review regulations. I don't see anything that requires Francistown to have a 120-day requirement. Our 120-day requirement is in our ordinance based off of New Hampshire RSA 676-4. So if you don't have that requirement, I don't know if you're necessarily bound to any specific time frame for Francistown.
Okay. All right. Excellent. Yeah, that was I think going to be my next question. So yeah, thank you for taking a quick look at a different town. Let's see. I've got another question. Speaking of lawyers, should a planning board have a different attorney or a different law firm than the city uses? Would using the same firm be considered favoring the city versus an applicant?
So the planning board probably itself does have the same attorney as the town or city, because it's the same entity, but an applicant should absolutely have their own attorney. It's that's because the city, they're representing their own and their own thing, and it's just, we would always recommend clients, you have your own attorney representing you. So yeah. So that's just a recommendation from people at the front desk.
Sure. We have the same attorney here in the city of Somersworth, representing both parties.
Yeah. Representing the applicant and the city?
Oh, no. Just the city and the planning board. It's all one.
Okay.
Yep.
Because in the end, that's who's paying, is the town government's going to pay the legal fees.
Yeah.
Yeah, makes sense. All right, so I think we've got one more question, unless other folks leave some. Oh, there's another question in the chat. All right. So my next question. Let's see. This is would it be considered bad advice if a surveyor comes to the board and wants to only resurvey a portion? Oh, I think we already answered that one. I'm sorry.
Yeah, I did.
Yeah. You okay? You got that one already.
Recommend that. Yeah.
Don't recommend that. Okay. Let's see. And we've got another one from Stephen in the chat. Doesn't the deed rule if there is a discrepancy between the length of a line described in the deed versus the length of that line marked on the ground? I would assume that what is marked on the ground is a mistake.
No, it's the opposite. So if the deed says, again, if the deed says it's 500, I'm giving you 500 feet, but on the ground and if they set monuments rule. So if it's a stone wall or they actually put a pipe, then whatever the distance is between those pipes, that is the actual distance. And for surveyors, we do go by the deeds, but what we find out in the field based on that deed, that is the correct distance. Back in the day, and I'll go out and I'll check a piece of property and I will literally pace it. I know how many paces I have for so many feet. But would I tell somebody, well, that's what you have? No, but so the plan and the deed are representing the same thing. The plan is much more accurate. And the same thing with acreage. The interesting thing about acreage is I could buy a piece of property and the deed says it's 20 acres. We go out and survey it and we find out it's 45 acres. Well, shame on you, town. You don't get any more taxes. You've been taxing them on that deed. They've only been paying for 20 acres. Then does that person really want to have that plan recorded? Because now it's going to be on record, that it's 45 acres. So so you do have that. And that's why perhaps a lot of boundary plans don't get recorded. They don't have to be if we're just doing a boundary plan, but that's, and it works both ways. And I couldn't go back to the town and say, well, my deed says I have 20 and now I only have 15 and you've been taxing me. Well, now you record that 15 acres and the town can reduce your taxes. So, you find the same thing, Kelly? Yeah.
If I may add to that, and that's where the GIS comes in. When people from other states come in here, GIS is king. I ran on that. I said, this is the boots on ground state. You're not determining whether I'm a soil scientist. You're not determining someone's going to GIS. We are a boots on ground state, and I people to surveyors all the time. I love our surveyors and we need more of you. But when I explain people GIS and other places, we are original 13 colonies. Our Constitution, which we are constitutional officers, predates the United States Constitution. We love that about our state. And I say to other states and people from other states, you got smarter, so you moved west and you GIS, you gridded everything off and did little boxes. I said, look at Boston, look at New York City. It's a maze of a mess. We were original. And that's why our records at the Registry of Deeds are so important. Ours go back to 1774. We have everything, and everything is online now available, thanks to ARPA money. And I'll compliment the Registry of Deeds for all the work we did, all the blood, sweat, and tears I did to make that happen. And I say to my delegation, it's everyone in the world that wants to invest here that now can read and make that determination whether they're going to invest or not. But we're not GIS because we are original.
Brendan, on the so there was a follow-up, the walking distance or the line of sight. So it's that measured distance that would make, let's say, the distance of a line, whether it's frontage, side lot lines, or anything. It's that measured distance, but it would have to be by a surveyor. It can't be by, Harry homeowner. And so by the line of sight, we refer to those as a tie course. If your property line goes along a brook, so, you actually own along the side of the brook or the center line of the brook, wherever that may be, we as surveyors will put a tie course across that, so mathematically it can be a closed mathematical figure. But where that brook is actually your property line, and those brooks move. So, and they kind of move, over the course of time. But by the same token, if there was something major that happened, let's say we had an earthquake and all of a sudden that brook went major difference, your property line in that case doesn't move. It stays where it was originally because that was, let's say, a huge thing that happened. Okay, so then somebody said, what if pins were moved? That's the surveyor's job. One thing that people don't, I already said monuments rule, but if we can prove, if somebody goes out and puts a pin in or a bound or whatever, and I know, okay, it doesn't make sense, and we know that it has been moved, the corner is the original corner. So, and people move pins all the time. I don't know what the heck they're thinking. And that's against the law in New Hampshire. So we have to be careful of that, but that's where we as surveyors, I'm surveying your parcel, but I have to absolutely take into account the abutting lot. And that abutting lot is just as important as yours is. So that's that. And then Lee asked again, if there were hills, would that make it longer than the line of sight? Hills is elevation, and in surveying, we take into account that vertical. We have to mathematically, we make it horizontal. So you in the field might see that it's have that elevation change, but when we do it, it's that horizontal. It's like the whole piece comes up and everything's like that. So, so that's a scoop.
That's what I say about our problems with cell towers in Grafton County. We're topographic.
Yeah.
All right, excellent. Well, I think that actually closes up all of our questions. And yeah, we'll post a recording of this webinar, so anybody who's here can refer back to it if they'd like. We've also got a survey in the chat. Let us know how we did. If this was useful for you, we would appreciate it. We like the feedback. But yeah, thank you once again to all our speakers. Thank you so much for joining us, everyone, and yeah, attending our webinar, and come back next month. We're a little early this month, but yeah, hope to see you all soon. So yeah, thank you, Shane, Kelly, and Cynthia.
Thanks, everyone.
Thank you, everybody.
All right, we'll see you all next time.
See you next time.